For a long time, right, when we talked about corporate compliance, it felt a lot like, I don't know, building a fortress, but entirely on paper.
Yeah, absolutely. A theoretical fortress.
Right. You draw up these beautiful, elaborate blueprints. They'd show a giant steel vault door, maybe some 3-foot thick concrete walls, an intricate laser alarm system. And then when the regulator finally came knocking, you just slid that blueprint across the mahogany table.
And they'd look at it, nod, stamp it approved, and just walk away.
Exactly. But welcome back to another deep dive, by the way, because if you're listening to this, maybe you're prepping for a big strategic meeting or just trying to stay ahead of the curve. We are unpacking a massive shift today. That whole blueprint era, that reality we've lived in for decades. Stepping into the regulatory landscape of 2026, that blueprint suddenly means absolutely nothing.
No, it really doesn't.
The regulator, they no longer want to see your drawing of the vault door. They are showing up at your actual server facility or, your cloud provider with a team of professional digital bank robbers. They're handing those robbers a blowtorch and basically saying, let's see if the steel actually holds up in real time.
Yeah, we've essentially entered the era of proof in practice. It's a global regulatory reckoning.
Proof in practice. I like that. And today, our mission is to unpack the towering stack of international regulations taking effect literally right now.
Okay.
To do this, we're synthesizing a ton of material. We've got law firm briefings from Foley and Lardner, Squire Patton Boggs, DLA Piper.
Right, plus those deep compliance guides from cybersecurity firms. Like UpGuard, BDO, CBIZ, and Remedio.
Yeah, and we're even layering in international strategy reports from the Partnership on AI and the ITU. It's a lot. And honestly, making sense of this maze is exactly why tools like www.compliancehub.wiki and CISOmarketplace.com have become indispensable for today's professionals. I mean, you cannot track this in a spreadsheet anymore.
No, absolutely not. The shift is monumental. Because regulators, they're no longer asking what your policy is, right? They're demanding automated, real-time, undeniable telemetry, proving your systems are executing those policies 24 hours a day.
Which is terrifying for a lot of companies.
Oh, yeah. And the catalyst for this crackdown is twofold. First, the sheer severity of data breaches over the last 5 years proved that annual PDF audits were practically useless against active cyber threats.
Right, the blueprint was just a shield for plausible deniability.
Exactly. And second, the fundamental architecture of technology has changed. Yeah. The perimeter has completely evaporated. I mean, we rely on decentralized cloud providers, endless webs of third-party software, open source code, and now autonomous AI.
The attack surface isn't just a single building anymore, it's infinite.
Yeah.
So let's start in our own backyard, right? Because the United States has engineered an incredibly complex trap for businesses. It's this dizzying state-by-state patchwork of privacy laws. As of April 2026, 20 different states have enacted comprehensive yet totally distinct privacy regulations.
20 independent legislative frameworks. And each one carries its own definitions of personal data, its own enforcement mechanisms, and critically, its own jurisdictional thresholds.
California obviously started the domino effect years ago with the CCPA.
Right, but the landscape fractured even further on January 1st, 2026, when Indiana, Kentucky, and Rhode Island activated their laws.
And the thresholds, that's where the trap actually snaps shut on a business. Let's look at the math here. In Indiana and Kentucky, the new laws apply to any business that handles the data of 100,000 or more residents of those specific states.
Which sounds like a fairly high bar.
Right, a local bakery probably isn't hitting that. But Rhode Island's law, which also fired up on January 1st, drops that threshold down to just 35,000 residents.
Yeah, and 35,000 unique visitors or customer profiles. In the context of modern web traffic, that is a remarkably low threshold.
I mean, a moderately successful national e-commerce brand could hit 35,000 visitors from a single state within, a few months of a strong social media campaign?
Easily. And it gets even more chaotic when you look at states like Delaware and Montana.
Oh, right, because they have no minimum threshold at all.
Exactly. The law there doesn't care if you have 1 customer or 1 million customers. If you are collecting data and doing business there, you are subject to the full weight of their privacy mandates.
It's like playing a high-stakes game of whack-a-mole, but all the moles are speaking different languages. So let's visualize the operational reality of this. If I'm running a mid-sized e-commerce site selling custom sneakers, right, and I have a warehouse in Ohio, how does my web server possibly know that the 35,000th visitor from Providence, Rhode Island just clicked on a pair of high tops.
Oh, under the old theoretical model, you wouldn't care.
Right. I'd just have one generic privacy policy linked at the very bottom of the page.
Yeah, for everyone. But in 2026, because of this fragmented patchwork, your website infrastructure cannot be static anymore. It requires centralized, dynamic geolocation routing.
Okay, what does that actually mean in milliseconds?
It means the moment a browser attempts to connect to your server, your system has to instantly cross-reference the incoming IP address against a geographic database.
So before the image of the sneaker even loads on their screen, my server is doing a background check on where they live.
It has to. It identifies the IP as originating in Rhode Island. Then, your backend database has to instantly query its own records. Have we processed data for 34,999 people from Rhode Island this year, or 35,000?
Wow.
And if you cross that threshold, your web server must dynamically alter the document object model, the actual code of the web page being served to that specific user.
Just for them?
Yes. It has to render a specific privacy interface that offers the exact, legally mandated opt-out mechanisms required by Rhode Island law. And if the very next millisecond a user from Delaware clicks the same shoe, the server has to render a completely different compliance interface for them.
The engineering overhead required just to show someone a pair of shoes legally is staggering.
It's massive.
And I think this highlights a massive philosophical divide between the US and Europe, right? Because Europe built the GDPR around an opt-in model. You have to actively check a box or click accept before a company is allowed to track you. But the US went all in on an opt-out model.
Yeah, led largely by California and Virginia initially. The default assumption baked into U.S. law is that businesses have the right to process, track, and monetize your data from the moment you arrive.
Unless you explicitly tell them to stop.
Right. You can collect the data, but you must provide an accessible, frictionless mechanism for the consumer to opt out of the sale or sharing of their personal information. And crucially, opt out of targeted advertising.
Which sounds simple until you have to manage 20 parallel operational workflows for it. I mean, if someone in Texas clicks opt out, the law might say I have 45 days to comply. But if someone in Colorado clicks it, the timeline or even the definition of sharing might be entirely different.
The administrative burden is immense. You're verifying identity, logging requests, propagating that request down through your entire marketing tech stack. But, regulators recognized early on that consumers were exhausted by this too.
Oh, absolutely. Nobody wants to visit 50 websites a day and manually hunt for 50 hidden "do not sell my information" links.
Right. And that fatigue birthed the most aggressive enforcement mechanism we are seeing in 2026, which is the global privacy control.
The GPC. I was reading the Foley and Lardner brief on this, and honestly, as a consumer, it sounds like magic. Instead of me fighting with cookie banners, my web browser just handles the negotiations for me.
That's the idea, yeah.
But mechanically, how does a browser actually force a website to stop tracking?
Well, the mechanism is surprisingly simple on the surface, but complex in execution. The GPC relies on an HTTP header. When you type a website address into your browser, you aren't just downloading images, right? Your browser initiates a digital handshake with the destination server. It sends a hidden packet of text, the HTTP header, saying things like, "I'm using Firefox on a Mac. Please send the desktop version of the site."
Okay, so it's just basic routing info.
Exactly. But if you enable the GPC in your browser settings, or via a privacy extension, your browser adds one extra line to that hidden text packet, SecGPC1.
SecGPC1. So it's just broadcasting a silent, continuous signal.
Yeah.
It's like walking into a massive shopping mall wearing a digital sign that says, "Do not track me." And every single store you walk into is legally required to read the sign and instantly burn any notes they were taking about your shopping habit.
That is a perfect analogy.
Yeah.
As of 2026, more than 11 states, including massive economies like California, Colorado, and Texas, legally mandate that web servers must listen for and honor that specific signal.
And it operates as a legally binding opt-out.
Yes, a frictionless opt-out request. You don't have to fill out a form. The mere presence of the header is the legal mandate.
But the sources indicate that websites are failing to honor this on a massive scale. If it's literally just reading one line of text, why is it so hard for IT teams to implement?
Because reading the signal is only 10% of the battle. The failure happens in the propagation. Your web server catches the GPC signal, sure, but your web server is also running dozens of third-party scripts.
Ah, like Google Analytics.
Google Analytics, Meta tracking pixels, TikTok advertising trackers. These scripts fire asynchronously in the user's browser. If your server sees the GPC signal, your code base must immediately, in real time, sever the data flow to all of those third-party marketing APIs. You have to programmatically force Google and Meta to treat that user as an anonymous ghost.
Wow. And if a Meta pixel fires and sends that user's browsing history back to Facebook to serve them an ad later, it doesn't matter if my server technically read the GPC signal, I still broke the law.
Exactly. You are liable for what the third-party tracker did on your site.
That is brutal. And state attorneys general are actually hunting for this, right?
Oh, very aggressively. They've utilized automated web trawlers to find these exact failures. They don't need to subpoena your privacy policy. They just point a bot at your website, have the bot broadcast a GPC signal, and then monitor the network traffic.
Just to see if your site still attempts to transmit data to an ad network?
Yep. And if it does, you receive an enforcement notice.
The California Attorney General has really made this their primary hunting ground. The standout example in the briefings is that $1.5 million settlement against Healthline Media. And the crazy thing is, Healthline wasn't fined for a data breach.
No, they weren't hacked.
They were fined because their underlying trackers failed to honor the GPC signal. So third parties were allowed to continue compiling profiles based on what health articles users were reading.
Right. And the Healthline case, alongside the investigation into Blue Shield of California, which was detailed in the Nixon Digital briefing, that underscores a critical regulatory trigger.
Which is sensitive data.
Exactly. Blue Shield faced intense scrutiny after a misconfigured analytics tool inadvertently exposed the health data of 4.7 million members. When the failure to honor an automated opt-out intersects with health-related search queries or medical portal data, the regulatory response is punitive and immediate.
It's the ultimate proof in practice test. I mean, Healthline undoubtedly had a privacy policy. Blue Shield had massive security teams. But when the actual operational technology was tested, when the GPC signal arrived, or when the analytics tool was deployed, the practice failed. The code betrayed the policy.
Yeah, beautifully said.
Which is why trying to keep all these state-by-state thresholds straight, knowing which states mandate the GPC and which don't, is exactly why a resource like www.compliancehub.wiki is vital. I mean, it acts as a centralized intelligence hub. You can instantly reference the specific technical requirements for Kentucky versus Rhode Island without having to pay a law firm to summarize the statutes every single month.
Because relying on static memory or outdated spreadsheets to track the legislative drift of 20 independent state assemblies, that is just a guaranteed path to enforcement actions.
Definitely. Okay, so we've established that managing standard consumer data, IP addresses, shoe purchases, browsing habits is an operational minefield. But if standard web traffic is under this much scrutiny, what happens when a user takes out their credit card or accesses their medical records?
Well, the stakes escalate from a privacy fine to a total business shutdown.
Right. So let's look at the financial and healthcare sectors. We have two massive updates hitting in 2026. We've got the enforcement of PCI DSS version 4.0.1 and a sweeping overhaul to the HIPAA Security Rule. Let's start with the money. March 31st, 2026. This is a hard deadline, correct?
It is a very hard deadline. March 31st, 2026 marks the definitive transition date for the Payment Card Industry Data Security Standard, version 4.0.1. On this date, all the advanced complex requirements that were previously classified as just best practices become officially rigidly mandatory for anyone processing credit card data.
And the fascinating thing about PCI DSS, which the sources note, is that it isn't actually a law.
No, it's not.
Congress didn't draft it. The state legislatures have nothing to do with it.
It is a proprietary global security standard engineered by the payment card brands themselves. Visa, MasterCard, Discover, American Express, JCB, they formed a council to protect their own networks.
But even though it isn't a federal law, the enforcement mechanism is arguably more immediate and devastating than a government fine.
Oh, without a doubt.
Mm-hmm.
Because if a government fines you, you pay the fine and you keep doing business.
Right.
But if you fail a PCI DSS audit, or if you suffer a breach and investigators find you weren't compliant with version 4.0.1, the card brands simply revoke your merchant account.
They just sever your connection to the global financial system.
Completely. You lose the ability to process credit card transactions. For an e-commerce business or a SaaS platform or even a brick-and-mortar retailer, losing payment processing is a corporate death sentence.
an immediate cessation of revenue. And version 4.0.1 represents a massive leap in what is required to keep that merchant account alive. You can't just buy a firewall, check a box on an annual self-assessment questionnaire, and call it a day.
No, the standard demands continuous, customized risk management now. And one of the most technically demanding additions in 4.0.1 addresses this massive epidemic of e-skimming, or match card attacks.
Right, e-skimming. Explain how that works for
So
us.
in the past, hackers tried to break into the main database to steal millions of stored credit card numbers at once. Today, they realize it's way easier to slip a malicious line of JavaScript into the code of the checkout page itself.
Just on the page where I type my info.
Exactly. As the customer types their credit card number into their browser, the malicious script silently copies the keystrokes and sends the data to a server in, say, Russia or North Korea.
Well, the legitimate transaction still goes through.
Yep. The customer gets their shoes, the business gets the money, and nobody realizes the credit card number was intercepted mid-flight until fraudulent charges show up weeks later.
That is terrifying. So how does 4.0.1 actually combat that?
It requires automated mechanisms like sub-resource integrity, or SRI. The web server must cryptographically verify the integrity of every single script running on the payment page in real time.
Every single script.
Yes. So if a third-party chatbot script on your checkout page is compromised and modified by a hacker, your server must instantly detect the cryptographic mismatch and block that script from executing.
Wow, it requires a level of live code monitoring that I imagine most marketing and IT departments have never had to implement before.
Never. Again, it's proof in practice. Show us the automated logs proving the checkout page is defending itself right now.
Okay, so let's pivot from the financial vault to the medical vault. Because the sources from CBIZ and Kodiak Solutions detail an impending, highly aggressive overhaul of the HIPAA Security Rule in 2026. But my first question here is, why now? I mean, we've had firewalls since 1998. Hospitals have been running compliance drills and making us sign those clipboards for decades. Aren't hospitals secure enough by now? Why do we need a systemic overhaul today?
Well, the architecture of healthcare delivery has fundamentally mutated over the last decade. The 1990s HIPAA framework was built for a world where a hospital had a literal physical server room in the basement.
Right. You build a strong wall around that room, you control the key, and the data is safe.
Exactly. But the modern healthcare ecosystem has completely dissolved that physical and digital perimeter.
Because the data isn't in the basement anymore.
It's distributed across a sprawling, interconnected web of hundreds of third-party vendors via APIs. Think about it. The MRI machine transmits highly sensitive diagnostic imaging directly to a specialized cloud analytics platform.
Oh, wow.
The patient portal is hosted by a SaaS provider. The billing and insurance coding is outsourced offshore. The appointment reminders are sent via an automated SMS vendor. A hospital is no longer a single defensible entity. It is an ecosystem.
So the cybercriminals realize they don't need to batter down the heavily fortified front door of the hospital's main network. They just look for an open window at the vendor that sends out the text messages.
Precisely. The supply chain is the vulnerability. In many of the most devastating recent ransomware attacks on healthcare networks, the initial breach didn't occur at the hospital.
Where did it happen?
It occurred when a hacker compromised the remote access portal of a third-party HVAC contractor, or maybe found an exposed API key belonging to a scheduling app. They used that trusted third-party connection to pivot laterally directly into the hospital's core electronic health record system.
And once they're inside?
They deploy ransomware, paralyzing patient care, delaying surgeries, and extorting millions. It's life or death.
So the 2026 APA update is an attempt to legally close those open windows across the entire vendor network.
Yes, it enforces elevated, rigorous operational security standards on what they call business associates. If your software, your cloud storage, or your consulting firm touches protected health information in any capacity, you are no longer loosely tied to the hospital's compliance. You are held to an incredibly high, independent standard of operational security. The regulatory liability extends deep into the vendor supply chain.
And beyond the pure cybersecurity aspects, the source has highlighted a very contemporary, highly sensitive focus within this 2026 IPAA update, which is the safeguarding of reproductive healthcare privacy.
Yeah, this is huge. The Department of Health and Human Services has implemented stringent updates to ensure that patient data regarding reproductive health is strictly walled off.
Because of the fractured legal landscape across different U.S. states regarding reproductive rights.
Exactly. The federal mandate clarifies that this specific category of health data must be protected from unwarranted disclosures, even in the face of certain legal inquiries that fall outside of authorized medical purposes.
But the engineering challenge there must be immense. I mean, an electronic health record system has to be capable of intelligently segmenting a patient's file.
Oh, absolutely. If a hospital receives a subpoena for a patient's general medical history, the system must be smart enough and legally bound to parse out and withhold the reproductive health data while still complying with the rest of the request.
It demands granular data tagging and incredibly sophisticated access controls. So the overarching theme for both PCI, DSS, and HIPAA in 2026 is that an organization is only as secure and only as compliant as the weakest third-party vendor embedded in its network.
That's the terrifying reality, yes.
And that exact realization that relying on unvetted third-party technology providers is a systemic risk is what has triggered the European Union to completely rewrite the rules of digital commerce. The EU is dropping the absolute hammer on operational resilience.
They really are.
We are looking at a massive regulatory fortress built on three pillars: DORA, NIS2, and the CRA. Let's unpack the first one. DORA, the Digital Operational Resilience Act. The briefings from SCOTCOM and Brooklyn Solutions focus on a looming deadline, March 31st, 2026. What does DORA actually do, and who is caught in its crosshairs?
So DORA targets the entire financial sector operating within the EU, banks, investment firms, insurance companies, and notably crypto asset providers. But the revolutionary aspect of DORA isn't its regulation of the banks. The banking sector has always been heavily regulated.
Right, so what's the new weapon?
DORA's primary weapon is that it directly regulates the bank's third-party ICT providers.
ICT meaning information and communication technology.
Correct. The massive cloud hosts like AWS, Google Cloud, Microsoft Azure, the data analytics firms, the specialized trading software vendors. Regulators looked at the financial system and realized that if three major banks all rely on the same cloud provider for their core processing, that cloud provider is no longer just a tech company.
It's a systemically critical piece of European financial infrastructure.
Exactly. If that cloud provider suffers an outage or a breach, the European economy basically grinds to a halt.
The analogy that comes to mind is health inspections. DORA treats a cloud provider the way a health inspector treats a restaurant kitchen. The regulators aren't just looking at the menu the bank hands the customer. They are walking back into the kitchen, swabbing the counters, inspecting the refrigerators, and interrogating the tech vendors who supply the ingredients. In 2008, we stress-tested the capital reserves of the banks. In 2026, DORA is stress-testing the routers and the servers.
That is exactly what is happening. And that March 31st, 2026 deadline, that's for the submission of the Register of Information. Financial entities must comprehensively map out and report every single third-party ICT contract they maintain.
Every single one.
Every single one. They must categorize the services provided, evaluate the criticality of those services, and quantify the risk. The goal is for regulators to possess a complete, transparent map of the entire financial nervous system, identifying the single points of failure where multiple institutions overlap on a single vendor.
But creating that register sounds nearly impossible for a massive global bank because of shadow IT, right? Where a single department might just expense a subscription to a new data visualization tool without telling the central IT department. Banks often don't even know how many vendors they actually have.
Which is why uncovering that shadow IT is a painful but mandatory part of the DORA compliance process. Furthermore, DORA explicitly champions that proof and practice philosophy. Regulators will not accept a vendor's marketing brochure claiming they have robust backups.
I want the logs.
They want automated, immutable logs, proving those backups are tested regularly, detailing the exact failure rates during testing, and documenting the remediation steps taken.
And the sources also talk about TLPT threat-led penetration testing. I assume this isn't just running an automated virus scan.
Oh, far from it. TLPT requires financial institutions to hire elite, independent ethical hacking teams. They have to simulate advanced state-sponsored cyber attacks against their live production system.
The live systems?
Yes, they mimic the exact tactics, techniques, and procedures used by real-world threat actors to see how the institution's defenses and their vendors' defenses hold up under actual fire. The results and the subsequent improvement plans are submitted to the regulator.
Wow. Okay, so while DORA locks down the financial sector's kitchen, NIS2 acts as the broader umbrella for the rest of the economy. The Network and Information Security Directive 2 expands these intense cybersecurity obligations to a massive swath of what the EU defines as critical sectors.
Right. Energy grids, transport networks, public health care, waste management. even digital providers like search engines and online marketplaces.
And the Kaimadio source on NIS2 highlights a massive shift in who takes the fall when things go wrong, the C-suite.
Yes. Historically, when a major breach occurred, the CEO could claim plausible deniability. They would assert that cybersecurity was an IT issue, express shock, and then unceremoniously fire the chief information security officer.
A classic scapegoat.
Exactly. NIS2 completely dismantles that defense. It introduces explicit personal liability for the C-suite and the board of directors.
So the CEO can't just hide behind the IT department anymore.
No. Management bodies are legally required to approve the cybersecurity risk management measures and oversee their implementation. And critically, they can be held personally liable for infringements. If an energy company is breached due to negligence, the regulators can suspend the CEO from their managerial duties.
That'll get their attention.
Absolutely.
Hmm.
And to ensure they can't claim ignorance, NIS2 mandates that the management body undergo specific, rigorous cybersecurity training to identify risks and assess the effectiveness of their security posture.
They actually have to understand the mechanics of the threats. And speaking of threats, NIS2 focuses heavily on securing remote teams against social engineering, right? The perimeter isn't just the cloud provider anymore, it's the employee's laptop sitting on their kitchen table. The briefing specifically mentioned vishing alongside traditional phishing.
Yeah, phishing or voice phishing has evolved terrifyingly fast. Attackers are no longer just sending fake emails with bad grammar. They're using AI-driven voice cloning technology to mimic the voice of a CEO or an IT director.
That is wild.
They call an employee who's working remotely, use the cloned voice to create a sense of urgency, and instruct the employee to hand over their multi-factor authentication codes or authorize a fraudulent wire transfer. NIS2 requires organizations to have verifiable operational defenses against these sophisticated human-centric attacks.
So the EU is fortifying the banks and the critical infrastructure. But the most revolutionary piece of the 2026 European Fortress focuses on the products themselves. The Cyber Resilience Act, the CRA, DORA, and NIS2 regulate the companies operating the services. The CRA regulates the underlying code. It imposes full lifecycle supply chain security requirements on hardware and software products placed on the EU market.
Right. If you manufacture a smart thermostat, a video game, or a piece of industrial control software and you sell it in Europe, the CRA dictates that you are legally responsible for the security of that product, from development through to its end of life.
And this is where we hit a statistic in the sources from the Open Regulatory Compliance Working Group that genuinely blew my mind. When you look at the code base of almost any modern piece of software, roughly 24% of that software is built in-house by the company selling the product. The other 76% of the code relies entirely on open source dependencies.
Code written by volunteers, academics, or communities, shared freely online on platforms like GitHub.
We have literally built the modern digital economy on a foundation of open source components. If a developer needs their app to process a JPEG image, they don't spend 6 months writing image processing code from scratch. They integrate a free open source library that already does it perfectly.
Right, but the CRA impacts that entire 76% open source supply chain.
So wait, if I'm a commercial app publisher and I use a free open source library for Bluetooth connectivity, and it turns out the volunteer who maintains that library accidentally introduced a massive security vulnerability,
Right.
am I liable under the CRA? Does the EU fine the publisher?
Yes, they do. The commercial entity placing the product on the market bears the ultimate responsibility. The CRA requires manufacturers to generate incredibly detailed software bill of materials, or SBOMs.
An SBM, like a nutritional label for software.
Exactly. It lists every single third-party and open-source component embedded within the product. The manufacturer must continuously monitor that SBOM against global vulnerability databases. And if a flaw is discovered in an obscure open-source library they used, the manufacturer must deploy a security patch and notify European authorities within 24 hours of exploiting the vulnerability.
The initial reaction from the tech community when the CRA was drafted was absolute panic, right? Solo developers maintaining open source projects in their free time were terrified they were going to be personally sued by the European Commission.
And the panic was justified, which led to intense lobbying and significant revisions to the legislation. The final text attempts to draw a line between commercial entities monetizing the software and non-profit open source stewards. This friction birthed initiatives like the Open Regulatory Compliance, or ORC, working group.
What exactly does the ORC working group do? I mean, how do you bridge the gap between a grassroots developer community and rigid European regulators?
Well, the ORC working group is essentially trying to create standardized, automated compliance frameworks that open source foundations can adopt without crushing their volunteer base. They are developing standardized vulnerability, handling specifications, and creating templates for SPOM generation.
Oh, I see.
The goal is to allow open source projects to signal to commercial users, hey, we follow these baseline security practices, which makes it easier for the commercial entities to absorb the legal liability of using that code under the CRA.
That makes sense. And honestly, navigating this whole European maze, finding third-party vendors that can survive a DORA audit, tracking down SBOMs for every piece of software to satisfy the CRA, ensuring your remote infrastructure complies with NIST 2 is exactly where a platform like CISOmarketplace.com becomes an absolute lifeline. When the regulators are demanding proof, you cannot rely on a vendor's promise that they are secure. You need a marketplace that actually vets technology providers against these intense 2026 European standards before you sign the contract. Because security and compliance are no longer the final checkbox in the procurement process, they are the primary gatekeepers for even doing business in Europe.
Absolutely. The EU is aggressively pulling up the drawbridge on insecure technology. But, while Europe focuses on resilience and supply chain fortification, Asia is fundamentally rewriting the physics of how data moves across the globe.
Which brings us to the Asian data borders. We are examining China's PIPL and India's DPDP Act. Let's start with China's Personal Information Protection Law. The sources from DLA Paper and Hoxford highlight a January 31st, 2026 deadline involving mandatory reports to regulators specifically concerning the processing of children's data. But the gravitational center of PIPL, the issue that is forcing multinational corporations to restructure their entire IT architecture, is cross-border data transfers.
Yeah, PIPL establishes one of the most impenetrable data localization regimes on the planet. The underlying philosophy driving Chinese regulators is data sovereignty. The data generated by Chinese citizens is viewed as a critical national resource.
And moving it outside the physical borders of China is treated as an issue of profound national security.
Exactly. They aren't just making it difficult. They've engineered a strict, unforgiving mathematical formula that dictates exactly what a company must do to move a single byte of data to a server in London or New York.
Okay, let's look at the math. If your company wants to transfer the data of more than 1 million individuals out of China, what happens?
Or, crucially, if you intend to transfer the sensitive personal data of just 10,000 individuals, which could include financial records, biometrics, or location tracking, if you hit either of those thresholds, you trigger a mandatory security review by the Cyberspace Administration of China, the CAC.
And this isn't a quick online form you fill out and get an automated email approval, is it?
No, it is a grueling, invasive, comprehensive audit of your global data practices. The CAC's security review takes a statutory minimum of 60 working days, and in practice, often stretches much longer. During this review, the business practically grinds to a halt regarding data flow.
What are they looking for during those 60 days?
The QA scrutinizes the precise business purpose of the transfer, demands detailed technical schematics of the overseas recipient's security infrastructure, and even evaluates the geopolitical stability of the destination country.
Wow. So they are essentially asking, if we let this data go to a server in California, what is the risk that U.S. intelligence agencies could access it, and how does that impact Chinese national interests? And if the CAC doesn't like the answers, the data simply cannot leave the country. But what if you are a smaller operation? Say you only need to transfer the data of 100,000 to 1 million individuals.
If you fall into that middle tier, you avoid the full, paralyzing CAC security review, but the obligations remain heavy. You have two primary options. You can execute a standard contract with the overseas recipient, which still requires filing a detailed impact assessment with the provincial CAC office, a process that takes roughly 15 days.
Okay, or?
Alternatively, you can undergo a personal information protection certification by a state-approved auditing institution. Regardless of the route, you are legally binding the overseas recipient to adhere to Chinese data protection standards.
The engineering required just to monitor those thresholds is massive. You have to implement real-time data mapping. Your systems must know exactly how many individual profiles have been slated for export so you don't accidentally transfer the 1,001st record overnight, breach the threshold, and trigger a massive federal investigation.
It's a logistical nightmare for IT.
And while China is aggressively policing the export of data, India is unleashing a monumental internal overhaul with the Digital Personal Data Protection Act, or the DPDP Act. The final hard compliance deadline is set for May 2027, but the strategy briefs from TCSA and SID Global Solutions emphasize that 2026 is the critical make-or-break implementation year.
The scale of the DPDP Act is difficult to overstate. It applies to the digital data of over 1 billion citizens. You cannot wait until Q1 of 2027 to start migrating systems. What is particularly notable about the Indian approach is how the legislation explicitly forces data privacy out of the IT department and drops it squarely onto the boardroom table. It is classified as a board-level risk.
And the penalties enforce that classification. The fines for noncompliance are astronomical, reaching up to 250 crore rupees, which translates to roughly 30 million US dollars per single instance of a significant breach or failure to implement security safeguards.
Yeah.
The TCSA source outlines a comprehensive 47-point checklist for DPDP implementation. This isn't just rewriting a privacy policy. It demands structural engineering changes, particularly for the BFSI sector: banking, financial services, and insurance.
Yeah. The 47 points cover everything from mandating the appointment of data protection officers who are physically based in India to implementing strict data minimization protocols. But the most disruptive engineering challenge lies in overhauling consent mechanisms. The DPDP Act envisions a highly sophisticated digital ecosystem utilizing consent managers.
I want to break this down because the consent manager framework is entirely different from how we handle consent in the US or even Europe. How does a consent manager actually function in the Indian digital ecosystem?
Okay, so instead of a citizen visiting 50 different banking and telecom websites to manage their privacy settings like we do, the framework relies on specialized, interoperable platforms, consent managers. A citizen logs into a central consent manager app. Through APIs, this app connects to every company holding their data.
Oh, wow.
Yeah, the citizen sees a unified dashboard and can instantly revoke consent for a specific bank to use their data with a single swipe.
So the moment the citizen swipes revoke, the bank's back-end systems must instantly register that API call and purge the data across all their operational databases. Building the infrastructure to plug into that national consent manager grid is what is consuming IT budgets in 2026.
It's a massive undertaking, and the cumulative effect of China's PIPL, India's DPDP Act, and Europe's GDPR presents an existential crisis for the traditional architecture of global enterprise. Well, for the last 20 years, the prevailing model was the global database. A multinational corporation would ingest customer data from Paris, Mumbai, and Beijing and dump it all into a single, massive, centralized server farm in California or Ireland to run global analytics.
Right. It was all pooled together.
But that era is completely dead.
It's legally and operationally impossible to sustain. You cannot commingle that data without violating multiple sovereign laws simultaneously. So, how does a multinational business even function? How do you reconcile the EU demanding strict privacy, China demanding localization, and the US demanding 20 different opt-out mechanisms without breaking your company in half?
It necessitates a fundamental architectural pivot toward data regionalization.
Yeah.
Corporations are deploying fragmented regional data hubs. European citizen data is processed and stored exclusively in EU-based data centers. Chinese data is locked within domestic Chinese infrastructure. U.S. data is federated across North American servers.
And the global headquarters.
They only receive highly aggregated, anonymized telemetry for basic reporting revenue numbers, high-level user trends, never the raw individual data.
But when data absolutely must cross a border, for instance, when a European employee needs to log into a US-based HR system, companies rely on highly fragile legal frameworks. The IAPP and BBB national programs sources discuss the EU-US Data Privacy Framework, the DPF. It's a treaty designed to facilitate legal data flow across the Atlantic.
The problem, though, is that corporate trust in the DPF is incredibly low. The European Court of Justice has a history of striking down these transatlantic agreements. They invalidated the original Safe Harbor Agreement, and then they struck down its successor, the Privacy Shield, largely due to concerns over U.S. government surveillance practices.
So companies assume the DPF is just living on borrowed time until a European court strikes it down again.
Exactly. This drives smart corporations to adopt a belt and braces approach. They might certify under the DPF, but they simultaneously execute standard contractual clauses, or SCCs, with their vendors.
SCCs? What are those?
SCCs are rigid, legally binding contracts approved by the European Commission. They act as a heavy legal gap filler. If the DPF is invalidated tomorrow, the SCCs ensure the data can keep flowing across the ocean without interrupting global commerce.
Keeping track of which data is flowing where and under what legal mechanism is exactly why centralized intelligence platforms like ComplianceHub.wiki are not optional luxuries in 2026. They are core operational requirements. It is exhausting just comprehending the human engineering required to map these data flows and manage the legal contracts.
He really is.
But here is where we take a massive leap into the unknown. Everything we have discussed, GDPR, PIPL, the fragment in U.S. state laws, was built on a specific assumption. These laws assume that human-generated data is being moved, analyzed, and protected by human engineers utilizing software tools directly controlled by humans.
Right.
But what happens when the entity generating, moving, and processing that data is no longer human? What happens when artificial intelligence transitions from a tool to an autonomous actor? We are looking at the 2026 AI governance priorities released by the Partnership on AI, which map closely to the milestones of the massive EU AI Act.
This is the frontier where every existing regulatory framework is currently being stress tested to its absolute breaking point. The Partnership on AI outlines 6 core priorities designed to prevent the rapidly accelerating capabilities of AI from outpacing our ability to govern it.
The 6 priorities are: 1. Governing AI agents with security and privacy protocols. 2. Strengthening documentation across the value chain. 3. International coordination, such as mutual recognition of AI audits. 4. Preserving human voice and epistemic integrity. 5. Public understanding and workforce resilience, which they call assurance literacy. And 6. Clarifying AI sovereignty goals. That is a dense philosophical list. I want to zero in on priority 1 because the technology described here sounds like science fiction that quietly became our daily reality over the last year. Agentic AI. How does an AI agent differ from the generative AI we've been using?
The distinction is critical. A generative model, like the early versions of ChatGPT, is fundamentally a tool. It is an incredibly sophisticated calculator for language. You provide a prompt, it calculates the most likely string of text to follow, and it outputs the response.
You are always in the loop. You read the text and you decide what to do with it.
Right. But agentic AI represents a shift from a tool to an autonomous actor. An AI agent is imbued with the capability for open-ended decision-making to achieve a complex goal. And critically, it is given the digital hands to execute that goal.
It has access to APIs.
Exactly. You don't ask an agent for a recipe. You give the agent a goal. Plan a dinner party for 6 people. The agent autonomously researches recipes, identifies the necessary ingredients, authenticates into your Instacart account via API, purchases the groceries using your stored credit card, connects to your Google Calendar to find an open date, and drafts email invitations to her friends.
It executes a chain of actions across multiple external systems without you hitting approve at every intermediate step.
Yes. Now transplant that capability from planning a dinner party to operating within a massive corporate environment. Let's see a CEO deploys an AI agent and gives it the goal: optimize our cloud storage infrastructure to reduce costs by 15%. The agent is granted administrator credentials to the company's Amazon Web Services account. It begins analyzing server loads and identifying redundant data.
And this is precisely where the Partnership on AI highlights the terrifying concept of non-reversibility of actions. If a human engineer makes a mistake in an AWS console, there is usually a fail-safe or a peer review process. If an autonomous agent running at machine speed hallucinates or misinterprets the value of a database, it could permanently delete the company's primary customer backup.
Or, tying back to our privacy laws, what if a marketing AI agent is tasked with finding new leads, and it autonomously cross-references a public database with highly sensitive internal reproductive health records, and then automatically emails that merged dataset to a third-party advertising vendor?
The damage is instantaneous, permanent, and completely violates HIPAA, the CCPA, and GDPR simultaneously. Governing agentic AI in 2026 means we need entirely new legal and technical infrastructure. The accountability frameworks are entirely unresolved. If an autonomous agent commits a massive privacy violation, who is legally liable? Is it the multi-billion-dollar tech company that trained the foundational model? Is it the enterprise that fine-tuned and deployed the agent? Or is it the individual employee who provided the initial, poorly phrased prompt?
The liability vacuum is staggering. And this leads directly into priority 4, which tackles perhaps the most profound societal challenge of the decade: epistemic integrity.
How do we preserve our ability to know what is fundamentally real?
Yes, we are flooded with synthetic media, AI-generated video, photorealistic images, flawlessly cloned audio. How does a society function when our senses can no longer distinguish human reality from machine output?
It is an existential threat to democratic institutions, financial markets, and basic social trust. The 2026 priorities emphasize a hard truth: we cannot rely on AI detection tools. Building a software tool to analyze an image and guess if it was made by AI is a losing game. It is a perpetual arms race against the generative models, and the detectors frequently produce false positives, accusing humans of using AI.
So if detection is a dead end, the focus is entirely shifted to content credentialing and provenance tracking, championed by standards like C2PA, the Coalition for Content Provenance and Authenticity. Instead of trying to detect fakes after the fact, we must cryptographically prove reality at the moment of creation.
Explain the mechanics of that. How do you cryptographically prove a video is real?
It requires hardware-level integration. When a photojournalist takes a picture of a geopolitical event, the image sensor inside the camera instantly generates a cryptographic hash, a unique digital fingerprint of the image data, the location, the time, and the device.
And that gets locked in.
That cryptographic signature is immutably embedded into the file's metadata. As that image moves from the camera to a photo editing software to a news website, every alteration is logged and cryptographically signed.
So when I see a highly controversial video of a politician making an incendiary statement on social media, I don't run it through a flawed AI detector. I click a button to inspect its digital credentials. If the video lacks a verifiable, unbroken cryptographic chain stretching back to a physical camera lens, I instantly know it was generated synthetically on a server.
It fundamentally rewrites the architecture of digital trust. We have to transition from assuming everything is real until proven fake to assuming everything is synthetic until cryptographically proven real.
Adapting to that mindset requires a massive evolution in how humans consume information. Which brings us to priority 5. The Partnership on AI talks about moving the global workforce toward assurance literacy. I love this concept. My analogy for assurance literacy is defensive driving. If you want to drive safely on a highway, you don't need to know the thermodynamic principles of a combustion engine, and you don't need to know how to write the code for the car's anti-lock braking system. But you absolutely must know how to check your blind spots, how to read the momentum of traffic, and most importantly, how to recognize the physical feedback when the car is hydroplaning or veering out of its lane.
That analogy perfectly captures the goal. For the last few years, AI workforce training has focused almost entirely on output generation, teaching employees prompt engineering to make the AI produce faster code or better marketing copy. Assurance literacy is the vital counterbalance. We must train workers to evaluate the AI's output with intense critical skepticism.
Teaching workers how to identify the blind spots of the model.
Exactly. An employee needs to recognize when an AI is confidently hallucinating a legal citation, or when an AI agent is exhibiting bias in screening resumes. Assurance literacy is about understanding the boundaries of the machine's competence. You have to know when it is statistically safe to rely on the AI's calculation and when human judgment, empathy, and ethical reasoning are non-negotiable.
Let's tackle the final point, priority 6, clarifying AI sovereignty goals. The Partnership on AI report discusses how nations are suddenly realizing the danger of being entirely dependent on foreign tech monopolies for their AI capabilities. I look at the phrase AI sovereignty and I see a polite diplomatic euphemism for technological protectionism. Are nations just using sovereignty as an excuse to hoard GPUs, enact export bans, and shut out global competition under the guise of national security?
It is the most sensitive geopolitical issue in the technology sector today. However, examining it neutrally through the lens of the policy briefs, nations are arriving at a stark realization. The infrastructure required to train and run advanced AI, the massive clusters of advanced compute, the hyperscale data centers, the critical minerals for microchips, and the immense energy grids required to power them are no longer just commercial assets. They are the foundational bedrock of future economic and military power.
It's the 21st century equivalent of owning your own oil reserves or steel mills during the Industrial Revolution. If you don't control the raw materials, you don't control your destiny.
The strategic argument is that AI has rapidly evolved into digital public infrastructure. A nation would never allow its entire physical power grid or water supply to be exclusively owned and operated by a foreign corporation or a rival geopolitical power. The risk of that entity simply turning off the tap during a diplomatic dispute is unacceptable. Nations view foundation models and compute access through the same lens.
If a country's entire healthcare diagnostics, financial forecasting, and logistics routing are dependent on an AI model hosted on servers in a foreign jurisdiction, that country lacks sovereignty.
Sovereignty in this context is the pursuit of resilience. Nations are investing billions in sovereign compute clusters and domestic open-source models to ensure their citizens, their scientific institutions, and their domestic industries have reliable, uninterrupted access to transformative AI capabilities, regardless of global trade wars or supply chain shocks. It undoubtedly creates friction, fragmentation, and export controls in global trade, but from the perspective of a nation-state, absolute dependency is viewed as an unacceptable security flaw.
It is an unbelievably complex, intertwined web of legal, technical, and geopolitical tension. So let's step back, take a breath, and survey the landscape we've just traversed. What an intense journey. We started in our own backyard, navigating the fragmented 20-state patchwork of U.S. privacy laws. We explored the engineering nightmare of dynamically geolocating users to honor the silent HTTP header broadcasts of the global privacy control, desperate to avoid the massive regulatory fines that hit companies like Healthline Media.
We transitioned into the heavily fortified vaults of finance and healthcare, dissecting the March 31, 2026 PCI DSS 4.0.1 deadline that demands real-time cryptographic monitoring against skimming attacks. We examined the HIPAA overhaul driven by the realization that the hospital perimeter has dissolved into a vulnerable web of third-party APIs while simultaneously battling to protect the extreme sensitivity of reproductive health records.
We crossed the Atlantic to confront the European Union's regulatory fortress. We saw how DORA treats cloud providers like critical infrastructure, demanding threat-led penetration testing and exhaustive vendor registers. We discussed NIS2 placing personal legal crosshairs on the backs of the C-suite, and the CRA attempting the monumental task of auditing the 76% of global software built on volunteer-maintained open-source code.
We then ventured into the strict data borders of Asia, mapping the unforgiving mathematical thresholds and grueling 60-day security reviews of China's PIPL cross-border transfer rules. We broke down the 47-point checklist and consent manager framework of India's DPDP Act, acknowledging that these forces have effectively killed the era of the centralized global database, replacing it with geographically isolated data hubs.
And finally, we stared into the rapidly approaching horizon of AI governance. We grappled with the terrifying liability of autonomous agentic AI that can permanently alter databases in milliseconds, the desperate need for cryptographic watermarking to preserve epistemic integrity against synthetic media, and the geopolitical race to secure sovereign compute power. It is an overwhelming amount of information and operational responsibility, which is exactly why attempting to manage this transition with outdated methods is impossible. You need intelligent, automated resources. That is why checking out the tools and vendor vetting available at www.compliancehub.wiki and CISOmarketplace.com is so critical. They provide the centralized intelligence and the verified supply chains necessary to survive the 2026 regulatory reckoning.
As we conclude, I want to leave you with one final overarching thought that ties all these incredibly complex threads together. We are currently engineering regulatory frameworks of unimaginable density. We are legally demanding that corporations track a single microscopic piece of user data through sprawling layers of open source code, routing it across fragmented global borders with wildly conflicting sovereign laws, all while that data is being actively ingested, processed, and acted upon by autonomous artificial intelligence agents operating at machine speed.
It vastly exceeds the cognitive capacity of human compliance officers armed with spreadsheets and PDF policies.
It does. Which forces us to confront a highly provocative horizon. Are we rapidly approaching the precise moment where our compliance systems, our security telemetry, and our regulatory frameworks have become so overwhelmingly complex, so unfathomably fast-moving, and so deeply embedded in obscure code architecture that they can no longer be comprehended, audited, or enforced by human beings at all? If the only entity capable of parsing the complexity of these laws and tracking the data at scale is another autonomous artificial intelligence who is ultimately auditing the auditors.
That is the terrifying reality of staring into a system that has outgrown its creators. Thank you so much for joining us on this massive, complex deep dive. Keep asking the hard questions, stay resilient in the face of this technical shift, and most importantly, stay compliant. We'll see you next time.